It does seem that most landlords and letting agents do know of the requirement to give their tenant written notification of the landlord's address for service, but fewer seem to know of the fatal consequences if this obligation is not met. Under Section 48 of the Landlord and Tenant Act 1987, a landlord must give a tenant written notification of the landlord's address for service of notices, including in legal proceedings. This is an address at which the landlord will accept notice or legal correspondence from the tenant. It does not have to be the landlord's home address necessarily. It can, for example, be an address of the landlord's letting agent. The problem is that where this is not complied with, Section 48 sets out that no rent will be lawfully due from a tenant until such time as the landlord does become compliant. This does mean that a tenant cannot argue that they do not have to pay rent for the period in which they did not have the landlord's address for service, because once the landlord has given that address for service in writing, all of the rent does become payable. It does become lawfully due from the commencement of the tenancy agreement. In the case of unpaid rent, before the landlord considers sending the tenant a formal demand for unpaid rent or an eviction notice based on unpaid rent, the landlord should check whether they're compliant with the Section 48 requirements. Has the landlord given the tenant written notification of the landlord's address for service of notices, including in legal proceedings? If they haven't, any demand for unpaid rent, any eviction notice served based on unpaid rent could be defective. And that can cause issues if the landlord later issues a claim for possession based on unpaid rent. So this requirement not being met can be fatal. In England, there is no specific form in which the landlord has to give the tenant written notification of the landlord's address for service. It is sufficient for the landlord to give their address for service within the tenancy agreement, but when doing so, the text should specifically state that the address given is the landlord's address for service of notices, including in legal proceedings, because that is the wording within Section 48. In Wales, there is a prescribed form that must be used when giving the landlord's address for service to the tenant. If you have any queries relating to compliance with Section 48, do contact our legal team and we will be able to assist you.